I'm Susan Allen, Benefits Coordinator with the Greene County Council on Aging.
I'm Dave Cusack of Cusack Law Office in Beaver Creek, Ohio.
We'd like to invite you to join us for our legal chat, brought to you by the Greene County Council on Aging. Hey, I just wanted to ask you some questions about Advance Directives. We have a lot of people asking about that.
Yeah, they're important documents. So, and sometimes people don't really understand what they are, and they don't. maybe they've heard of a healthcare power of attorney, or maybe they've heard of a living will, but sometimes the terminology is a little confusing. But they're Ohio Healthcare Advance Directives, and they're just that. We make directions in advance for our treatment. We have to be competent in order to execute those, and then it's for the purpose of having people make decisions for us when we're not able to. So our major documents there are the Ohio Living Will and the Ohio Healthcare Power of Attorney. So the living will, and sometimes we have people think that that's a will, you know, it's confusing.
Yeah, or they're afraid of it.
Right, right. Yeah, we get all the time that people say, well, if I execute a living will, then a doctor decides when I die.
Right. Or my child, who I'm not liking right now.
Right. So, but the living will is a document that you execute that says if I'm in a permanently unconscious state or terminal condition, then here are my choices, how I would want my treatment handled. So oftentimes we kind of think of it as an end-of-life treatment document. You have to be competent to execute it, and then when you do, it's available for that circumstance, which really is kind of end of life. Your doctor and another doctor have to have physically examined you and determined that you're in that state. So, and each document has the definitions of kind of these terms that we use in it. So if the person is a little confused, that can help explain it.
So if I've done living will, which I have, by the way.
All right.
I say I don't want, tubes, I don't want, but now my family is panicking. And can they override that?
No, so that's an interesting thing. So we'll talk about the healthcare power of attorney in a minute. But even if you had a healthcare power of attorney, that agent can't override the decisions you make in the living will. If you get to the point where you're in a permanently unconscious state or terminal condition, your wishes control in that document. It is your declaration. There are people listed on there, and sometimes they think they're decision makers, but they're not. They are listed on there to be contacted by the healthcare professionals in the event those decisions are being made. So you're in a dire circumstance, and they contact your family, give them a chance to get there, and I mean, technically they could pose an objection, but that would be a court thing.
I've had a couple where people thought they could override it.
Right, it is not the case. Yeah, so the living will, I used to think that the living will was a document that was a benefit if the person you name in your healthcare power of attorney changes philosophies on you. But really most often we see it as a benefit that people don't have to have folks second guessing their decision, right? Everybody, if I don't have to sign the paperwork, I always have my opinion, right? And so we get that. And sometimes family members, you would not want to leave a family member to be second guessed or to struggle and stress over a decision to terminate treatment or something like that.
And can you change that? Let's say, right now I'm saying, no, I don't want any extreme measures, but now I'm 80 and I'm thinking, ooh, maybe I do.
Absolutely, yeah, you can change it as often as you like. So, and when you execute a new document, you will revoke the previous one, and sure, that's totally up to you, as long as you're competent.
And do you have to go to an attorney to do these things?
No, that's a great question. You don't. We remind people that they're important documents, so if you're going to execute it yourself, you want to feel awfully comfortable that you understand it. But I send people to a website called leadingageohio.org, and they have a great explanation under Advance Directives. They have great questions. They have a publication that's in PDF form called Choices, and I think it's in its 7th edition.
And I think we have that in our office.
Yeah, it's a great document. Very simple language, and then again, within it, it has full healthcare power of attorney, full living will. And let's talk about the healthcare power of attorney.
So when is the healthcare power of attorney effective?
Yeah, so that's a confusing issue for some people, but a healthcare power of attorney is by law a springing power of attorney. It only becomes effective and grants an agent authority to act for you when you are no longer able to make your own informed healthcare decisions. The healthcare power of attorney is different. The living will is your statement about the way you want treatment in this specific set of circumstances. A healthcare power of attorney is much broader. It gives you the authority to name someone who would make your decisions in the event you can't. So let's say you're recovering from a stroke and you have not regained the capacity to make informed healthcare decisions. In that situation, your healthcare power of attorney would spring into effect and grant that agent the ability to make choices on your behalf.
Well, and that's a good question. So first of all, I'd imagine you want to be careful who you're naming as an agent.
That's right.
But we do have folks who have no family at all. Who else would they name as an agent?
Yeah, so it doesn't have to be family. You can name a friend or somebody that you go to church with, or you could. But and then it doesn't necessarily have to be age. Sometimes we have people concerned. I don't want to name my youngest child who's a RN because I don't want to offend my oldest child.
Yeah.
We tell people these aren't honorary positions. You're making important decisions, so we want somebody that you feel comfortable in that circumstance. But it doesn't necessarily have to be a relative. If you don't have anybody, then that's not really a time to just guess or choose someone. So that's
and can you do more than one person?
So you can. We generally advise against having co-agents. You want to have agents in the alternative. So if you name a child and they're not available, right, a successor, so that next person would be available. And sometimes we have a situation where somebody's called upon to make decisions, but they're not available. They may be in a plane. Mm-hmm. In that case, they immediately go to the next person in line. When the primary person becomes available, they regain their primary position. So,
well, that's a good idea. Yeah.
It is, yeah. So it's always good to have the alternates.
And this is healthcare power of attorney is not the same as a financial power.
That's correct. It's limited to healthcare. So, and most of the time when we execute a financial or a general power of attorney, we typically would make that effective immediately. By law, a healthcare power of attorney is not effective until you become unable to make your own informed decisions. We call that a springing power of attorney. So I can't tell you the number of times I had somebody in the office who said, I told the doctors I wanted mom to get this treatment and they wouldn't do it. I said, well, is your mom competent? Yes. Well, then she's making the choices, right? Yeah. So it doesn't allow you to override the will of the person who's made that, made that choice. It's just when they're not able to make informed decisions, then
because I do see a lot of people who are very nervous about the living will and the healthcare power of attorney because they're afraid someone's going to make a decision they don't want.
Yeah, so we deal sometimes with the populations that's concerned about losing independence, and we want to express this is an ability to have independence, to make choices that are your choices rather than have them made for you if you're not capable of making them, right? So, and I tell people the alternative is if you don't have these documents in place and you're not able to make your own decisions, then the only alternative is probate court and a guardianship.
Yeah, and that's a good question. That's why we really try to push people to do this, but you know how we all are. I'll do that later.
That's right.
Absolutely.
That's right. Absolutely. Yeah, I tell people, we want you to make decisions that give you the authority. And so when we have an Advance Directive, we might be afraid because we're thinking of somebody making decisions for us, but that's not the way I think about it. I think about it as you're choosing who will help you in that circumstance. Absolutely. So exercising your own power.
And you said we can update this, and do you recommend that we update every so often?
Yes. So as far as I'm concerned, there's not a magic number, but we suggest people look at all of their estate planning documents at least annually just to go over them, make sure they understand what's going on and that their choices remain the same. So if you're somebody who has a shoebox with tax documents in it or receipts, then put a note in there that tells you to look at it. Or if it's, you decorate for the holidays and you have
That would be me.
you have that Rubbermaid container with the ornaments, put that note in there and you'll remember.
Absolutely. Well, thanks. I just think this is great information. And Ken, that website you were telling us about, can we put that on this video somehow?
Absolutely. leadingageohio.org.
Excellent. Thank you for joining us for our legal chat. For any further information, please visit our website at GCCOA.org.